Check 5-6. Check 5-6. Check 5-6.
Yes, sir, you do. Paula Hefner.
Paula, what? I'm sorry?
Hefner, Hefner.
Thank you, Ms. Hefner.
We were actually together one day last week. I think it was last week. It may have been, I don't know. We lose our track, don't we?
I believe I remember. Well, it's good to have you back. Thank you.
Thank you. Thank you.
All right, it's now 8:30, so let's go on the record. Good morning. Today is October 26, 2023, and the current time is 8:30 a.m. The commission has set aside this time today for day 2 of an evidentiary hearing in the matter of the petition for an interim receiver and for an order directing the general counsel to petition the circuit court for the appointment of a receiver for Misty Waterworks, and that is file number WO-2024-0036. My name's John Clark. I'm the regulatory law judge presiding over today's proceeding. Also present today will be some of the commissioners. The commission is composed of 5 commissioners: Chairman Scott Roop, and Commissioners Maida Coleman, Jason Holzman, Glenn Kolkmeyer, and Kayla Hahn. And I know that currently we have Commissioner Coleman, who is going to be attending today via WebEx and is currently listening. And we will have other commissioners who may come in person or may choose to participate via WebEx. At this time, I'm going to ask counsel for the parties to enter their appearance for the record, starting with Mr. Blevins. Mr. Blevins, you're representing Misty Waterworks, yourself and your wife. Is that correct?
I'm representing myself and my wife.
Push your button. Push your button.
Okay.
And you can move the microphone closer to you.
Okay. I am representing myself. The Misty Waterworks is a DBA term that's, if that's...
You've explained that before, and I imagine I'll have some questions for
Yes,
you
sir.
about that. But you're representing yourself. You're not represented by an attorney. Is that correct?
I didn't hear the last part of the
You are
question.
representing yourself. You are not represented by an attorney. That's correct.
That is correct.
Okay. On behalf of the staff of the commission,
Carolyn Kerr.
And Casey Aslin.
Ms. Kerr, Ms. Aslin, thank you very much. And is there anyone here from the Office of the Public Counsel? I hear no one. With that in mind, we're going to pick up where we left off yesterday. I am going to say, are there any preliminary matters that need to be taken care of at this time?
I don't believe so.
Okay. I know that staff had at one point had an Exhibit 8. According to my notes, that hasn't been offered yet. I don't know if that's something staff is cognizant of or not.
Yes, I think I was going to try to get that in, later with Mr. Blevins, since it was something that he signed.
Okay, and that's fine. I wasn't trying to tell you how to do it. I was just reminding you that that was out there.
Thank you.
Okay, at this time, staff may call their next witness.
I'll call Kurt Gately.
Mr. Gately, would you please take the stand? Would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at today's evidentiary hearing is the truth?
Yes.
Please be seated. Staff, you may question your witness.
Thank you. Good morning.
Good morning.
Could you please state and spell your name for the record?
Curtis Gately, Curtisgateley.
And by whom are you employed and what's your position?
Public Service Commission. I'm the manager of the Water, Sewer, and Steam Department.
And just generally, what are your job duties and responsibilities?
It's pretty broad. I oversee staff who review and provide recommendations on applications before the commission, and I also oversee folks who do investigations and inspections.
Are you Adam Stamp's supervisor?
Yes.
Okay. And are you familiar with Mr. Blevins?
Yes.
Are you familiar with this investigation regarding Mr. Blevins' business?
Yes.
Okay. And what's been your involvement with this investigation? just
I
generally?
was part of the initial contact from DNR when they presented their concerns about the situation, and then worked with Adam in his investigation, and I also did some of the site visits myself with Adam.
Okay. So you said you did some of the site visits. Do you remember seeing any of the well sites?
I did see some of the sites. I did not attempt to enter any of the well houses, that sort of thing. It was more of a just laying eyes on the facilities as part of the same trip when we initially met with Mr. Blevins.
Okay. All right, so you don't know any of the specific, or you don't remember any of the specifics or anything?
I don't remember, for example, which street names
Okay.
that the wells were on that I visited.
Okay, that's fine. Do you remember talking to Mr. Blevins?
Yes.
And do you, can you just describe how, what did you talk to Mr. Blevins about?
We met with Mr. Blevins to discuss and explain why we were looking into his business. The process with the Public Service Commission, most folks don't know what we do. So I can't assume that someone who I'm not dealing with a professional that they've hired who's familiar with our stuff. I was going to sit down and explain the situation. And we had a discussion for, I believe it was less than an hour, but about the complaints we'd received, the concerns we had, what we were investigating, and ultimately what it might take if Mr. Blevins wanted to become get a certificate from the commission to operate legally.
Did he seem cooperative with you?
Reasonably so, yes.
Did you seem to understand what you were there for?
As much as someone can in a first meeting like that, yes. We went over several subjects, and I wouldn't expect a layperson to immediately understand all of it, but yes.
How often did you personally meet with him?
I only personally met with Mr. Blevins once as a one-on-one meeting. He attended the public information session that we had, but I don't recall if we had another discussion separately at that one.
Okay, so was that basically your involvement with Mr. Blevins?
Directly, yes.
Okay. And with regard to PSC, as a supervisor, what are you looking for, what was your concern with Mr. Blevins, with the complaints that you were receiving with the investigation?
With the complaints that we had received from customers and the details we had been provided from the Department of Natural Resources, my concern, number one, was the safety of those customers. We had folks who couldn't drink their water, or if they were putting their lives in danger. And being familiar with other situations, also in Pulaski County, where substandard wells had been constructed to intentionally try to dodge regulation from DNR and PSC, we had a lot of concern about the integrity of those wells, if the rest of them were safe. Customers were most frustrated with what they viewed as double dealing by Mr. Blevins, because they had contracts for water supply at a certain rate, and those contracts, the terms of which were changed on them without notice. That showed to us that not only was Mr. Blevins offering himself out as a public utility and charging for service, but also doing so in an unsafe manner.
And is that a concern for the PSC?
Absolutely.
And how so?
The PSC exists to protect customers who are subject to a monopoly like this one, and to make sure that they are paying just and reasonable rates and have safe and adequate service. And when companies try to operate without that operate outside the law, those protections don't exist.
Okay, and is it your opinion that Mr. Blevins' operation is not regulated?
Not currently regulated by the PSC, correct?
Okay, and so it's, so what are the concerns with regard to the customers then, if it's not regulated?
The lack of oversight and the lack of rules on how you set your rates. And then in this situation, there are wells that otherwise would be regulated by the PSC and therefore subject to scrutiny and compliance with environmental regulations that otherwise those customers have no such protections.
And you talked about adequate service. What does that mean?
It's a broad term. Adequacy is not just, the first thing folks think of probably is outages or a lack of water pressure. Pressure is actually a safety issue. A customer might consider it adequacy, but for us, it's a safety issue because the pressure rules exist to make sure that no contaminants can leak into a distribution system. For us, certainly the concerns with outages, a lack of maintenance, preventative maintenance to reduce outages to the degree possible. Compliance with our rules on how you bill, how you have customer contacts, actually returning phone calls. A lot of the customers told me that they would call and have the number they were told to call, and it was a full voicemail and couldn't reach anyone. Mr. Blevins has experienced his own personal challenges, but there has to be someone else, some kind of backup, somebody that a customer can reach with a problem. A customer needs to be able to request that their service be turned off if they have a service line issue in their own yard. They need to be able to get a hold of a company for the basic utility services that everyone expects. And customers were telling us that they weren't receiving that kind of service. The situation at one of Mr. Blevins' wells where on the lot what appeared to be campers or RVs were parked and there was no provision for sewage. There is no situation where sewage should be straight piped, but in this case, you had customers calling and complaining to us about an entity was allowed to dump sewage beside a well. That it's not yet a safety issue, but that's a demonstration of a lack of adequate service that would prevent safety issues. There are probably more examples that I haven't gone into, but that's some of them.
Okay, and is all that incorporated into the memo in the memorandum that was filed with the petition that you know of, which is Exhibit 6?
I believe that was done prior to some of the more recent information that customers had complained to us about that we had not separately tried to redocument. But yes, most of that is in that memo.
Okay. So the PSC, so what is so the PSC filed this petition for a receivership. What would, does that go into the basis for that, or what was the basis?
Receivership is our most extreme option. The situation with Mr. Blevins, in my opinion, is one where folks are currently not receiving safe and adequate service, and he has demonstrated either an inability or a lack of desire to bring facilities into compliance. Either one of those situations endangers customers. That wouldn't even get into the types of rates they're paying and such. I don't know what number under our rules they would end up paying. but right now there's no review of it at all. So those situations, in our view, there doesn't appear to be a situation where Mr. Blevins could simply get a certificate and bring the facilities into compliance. He lacks the, for lack of a better term, the infrastructure within his business he can't wave a wand tomorrow and become a proper utility company. But his relationship with DNR and the facility being on a boil order for so long, the lack of testing of the other wells to see how bad they might be, because we expect they're probably of similar construction. All those, to me, suggest that a utility company that has demonstrated an ability to bring facilities into compliance and operate them properly is the best choice for customers going forward.
Okay. I don't have any other questions, thank you.
Mr. Blevins, do you have any questions for this witness?
I do. You mentioned complaints. What complaints did you actually receive?
Are you asking how many or the details of them?
Well, I've never received any complaints in writing from you folks, but you indicated that there were complaints. Were there? Did you have that in writing, or how did that get into your knowledge or whatever?
So there were customers who had contacted DNR to request assistance, and DNR put us in contact with those folks, and we let them know that there was a process for anyone who has a complaint about a utility company to file those with the PSC through our electronic docket system. I do not recall if I actually spoke with any of the folks who had filed the complaints, because one of my staff was the lead on that.
You said
But
filed.
I did read them.
You said filed the complaints and you read them?
Yes.
And what did you do with them after that?
Because the nature of the complaints and the information from DNR showed that we were potentially dealing with an unregulated utility, the investigation then shifts to the utility itself, because with the complaints, staff is charged with examining whether a company violated their tariff or other provisions of the law. And there isn't a tariff to compare to for a company that isn't yet regulated.
Am I understanding that from that point then you did not go into any mode of trying to help the situation, or just to attack the situation?
We met with the person who was providing the service and tried to explain the nature of the investigation early on, but it rapidly became clear to me that this was a situation where we were not going to be able to have a facility come in and be or a company come in and be regulated. Instead, we needed an entity with better resources to step in.
How long had this person that we're talking about, which happens to be me, how long did you think that the wells were in operation by me?
Well, I've heard at least 3 different amounts of time. In our initial meeting, you were, somewhat upset with our appearance and discussion about this subject. You had said that it had been going on for 40 years, and why was this a problem now? Yesterday, I heard you say that you had only been operating the wells for 3 to 4 years, and then later on said that you had taken them over 20 years ago. So I don't know.
Well, okay, so at that point then, it was not your position then with the problem that you indicated from complaints and the DNR, asking you to assist, was that assistance supposed to be providing help to this individual or this company or whatever you tried to make this, call this company, utility? Was your efforts to help that or to just dispose of it?
With the regulations I operate under, there is no specific provision that I'm here to assist a utility company or to assist a particular customer or company, that sort of thing. My initial examination of it, of the information that was available to me at the time, and what I know through my career, meant that my number one priority was the safety of those customers. And how we get there, the most efficient way. I had no particular agenda to assist you and your company, or to assist the customers with forming their own homeowner associations, any of that. My number one priority was fixing the situation. And the more I learned, the more concerned I became. And no, I did not, after receiving quite a bit of information, I was not in any, making any further efforts to assist you.
Okay. You mentioned that earlier that you seen something that looked like people were dodging something or double dealing. What do you mean there? How did you determine anything like that?
For the double dealing reference, that was my attempt to explain the customers being upset at having contracts, which I've seen at least 3 of them where folks came to me and showed me that they believed they should be paying, I believe it was $35, but a certain amount, and that rate had been changed on them, and more than one of them had hired an attorney to consult with, and were going to sue under breaking that contract. The evasion of DNR regulations when wells like these were constructed, I had seen it before during my career when I was at DNR, and I had seen it in previous cases where the commission had to step in and order an entity to become certificated. That company then failed, and we had to do a receivership and take it away. But wells that were intentionally drilled and set up to supply only a few customers to try to stay below DNR's rules on having to sample them, not constructing them properly. I had seen that before. And after a major court decision that changed things for the way DNR can regulate some of these, they regained some more power to ensure safety. DNR's rules are set up for, and it comes down from the federal law, it's about the amount of risk. The more people that are put at risk, the more regulations are applied to a well. Down to, when you get down to individual wells, there really aren't rules for sampling or licensing for a well for an individual home. These situations where developments in Pulaski County and probably in some other counties where a developer chose to punch multiple wells instead of installing one adequate well and a centralized distribution system, to me is clearly an effort to evade DNR rules. And I'm not alleging that you constructed those wells.
Well, that was my question. Did you determine when these wells were constructed and who constructed them?
I've heard anecdotes. I did not personally try to run down those details because in my current role with the PSC, it's more about rectifying the current situation than trying to go back and address violations of DNR law historically.
You mentioned outside the law, operations outside the law. What do you mean by that you determined was outside the law?
It's a nicer way for me to say someone is operating illegally on purpose. There is no situation where a utility in Missouri that is charging for service and serving the public should be able to do so without following the PSC rules and being subject to the same rules that other utility companies are subject to. In addition, those rules are set out to protect customers in a monopoly situation, and those laws exist for a reason. Folks who are not following those laws are operating outside the law.
How did you, what would be, or how did you determine that something was done on purpose when these wells have been in operation for in excess of 20 years already and has never been subject to your rules? As I don't understand why 20 years. Can you explain to me why 20 years these wells were operated the way they are today?
I think that there are a lot of things that go on that we don't know about. I think that even if we had a lot more inspectors and a lot more investigators, we would not be able to identify every situation that was going on that shouldn't be that way. When customers complain to us, we're going to investigate. But no, I do not have an explanation for how it was constructed and the evasion of the rules for so long. I don't.
Again, you mentioned that you have complaints.
Yes.
And you investigate that complaint. The complaints that you alluded here, how did you investigate them?
My staff member contacted those customers, asked for some documentation that they might have to support their positions, visited the sites and saw for himself what the physical situation was. We then realized that we appeared to be dealing with an unregulated utility that should be subject to PSC rules, but because there's no tariff in place and the company had not received a certificate, our investigation had to shift to then dealing with that unregulated company because there wasn't an ability to say to a customer complaint that there were violations of a tariff when no tariff was yet in place.
You mentioned prices earlier. How did you determine that the price that you've seen in reference to maybe the complaints about pricing, was it too high, too low? How did you determine that the pricing was incorrect, I guess?
Well, I haven't made a determination that it's incorrect. We have not been able to conduct an audit to determine the cost to provide service. And I don't know that I mean, just professional experience, $35 seems a little bit low. Customers had told me that they were now being asked to pay quite a bit more than that. I don't know what the proper price is yet.
What is quite a bit more than that?
We're going off my memory, but I believe that I was told by customers that they had been raised to $55 to, I believe someone told me $70, but that may be incorrect.
Okay. Do you consider $55 too high?
I don't know. There are situations where some companies with, under PSC rules have rates that are lower than that, but it's very site-specific and depends on that company's cost to operate and how many customers are there.
Okay. But did you determine the cost of operations in your investigation?
No.
Okay. You mentioned pressure. Pressure in the wells?
Pressure at the residences.
Pressure at the residence. Can you explain that to me, please?
The DNR has regulations on minimum pressure, and that water being the way it is, it can vary a bit in the distribution system, but in no situation should it be below, I believe it's 20 psi, pounds per square inch. The goal there is to ensure that if there's a leak in a water line, the water's leaking out, not leaking in. The water lines are in the ground, obviously water getting in could introduce contaminants. It's allowed to be quite a bit higher. Coming into my house, I had to install a pressure reducing valve because it was tearing up my equipment.
Was it determined that pressure in these wells, since you mentioned it, was wrong? Or
I don't remember that I have seen documentation of operating below 20 psi when the wells were in operation. Obviously, there's been outages complained about, but customers have routinely expressed to us their dissatisfaction with pressure. Not at all of the systems, obviously, but at some of them. But that's why I mentioned it, was that while a customer has, well, multiple customers have complained to us about pressure, we sometimes get customer complaints about pressure that are operating legally, but the customers don't consider it adequate.
did you investigate any of those complaints? Specifically,
I don't believe that we put a pressure gauge with a data recorder on ourselves.
Okay.
And I don't remember if DNR did.
okay, you also mentioned billing. Was there any mention in the meeting that there's any billing going on for the water that's used?
Which meeting? The public meeting where we had
No,
customers?
the personal meeting, I think, you were talking about.
I don't remember. We covered a lot of ground because it was your first introduction to these, and I really don't recall.
Do you do you remember how the customers were charged then?
Customers showed us bills from, what's my understanding is two of your businesses, that the fictitious names, the Outlaw Corral and the Misty Mountain or Misty Waterworks. They also told us that they had had verbal billing, that folks had come door to door to try to collect. They and then during the meeting when I met with you personally, two customers were there, and I witnessed you and a customer negotiate some other price, it appeared, but I didn't try to write that down or keep track of it. That customer, is my understanding, was writing one check to cover a number of months. So to me, the billing was, there was not a consistent way that bills were being received, which is required by our regulations.
Were you familiar with, or was you provided with a document that said agreement to furnish water?
I believe I have reviewed at least a couple of those, yes.
And what did you think about that particular?
It demonstrated to me that you, the water provider, were putting yourself out there to provide water service to the public.
Who do you call public?
I'm sorry.
Who do you call the public?
In this situation, I'm talking about the people who live within the subdivisions where you provide water.
Did you, in your investigation, determine whether or not there was any other source of water available to these people?
Yes.
And were there other sources?
In most situations, no, there were no other existing sources. We learned of the line that existed from the Pulaski County Water District that would serve a small number of customers. But our investigation reaching out to the local municipalities and that water district showed that it would be cost prohibitive for any of them to try to provide service, primarily due to topography and distance. It's not flat ground.
Am I to understand then that in your investigation you determined that there was no public service for water available on a reasonable basis or a reasonable cost?
No alternative sources, correct.
No alternative. Okay. I'd like to get your determination as to what you actually investigated and saw, that for you to say that the safe and adequate operations are not safe and adequate.
Well, I think it's the easiest way is to start with the bacterial contamination that wasn't fixed. Any company that my group oversees that would allow folks to be exposed to contaminated water for 8 months will have a complaint filed before the commission. That's not acceptable. It's not acceptable to anyone. The problems that were relayed to us from customers of wells being improperly shocked, customers complaining to us about having to take their children to the doctor because they had chemical burns from chlorine. While that's not, direct evidence that I obtained, it's something that we have to investigate when customers complain of that. And it was corroborated by experiences that DNR had and some of the statements they had from the operator, the licensed operator. That's a demonstration of not receiving safe service.
I see. You indicated that someone had a chlorine burn. Did you investigate that? Did you collaborate that with a doctor or something?
No, and there's a few reasons for that. Number one, we didn't have to as part of, it wasn't the most important part of this case. The most important part of this case, in my mind, is a company is operating without a certificate and does not appear to have the wherewithal to operate properly if a certificate was granted. The second reason is that if I try to start bringing in documented health conditions with a particular person into a case, there's federal privacy laws. I would like to avoid having to make a customer come in and testify in a case like this when it isn't necessary over any of them. We do have customers who come in and testify in complaint cases when they have a complaint against a regulated utility and are asking for some kind of relief. But I'm not generally going to try to force other folks to come in with that sort of thing. They volunteered it. We did not make that a key part of our presentation before the commission.
Am I to understand then with your testimony that on the initial meeting that your determination was not to get really a certificate of convenience and necessity, but to oust out the whole situation, to eliminate it and put it somewhere else.
I don't know when, I didn't write down or document when my attitude on that shifted. The initial meeting was absolutely about, this is the process for becoming certificated, and this is what we have to investigate. I do remember more than one meeting amongst staff members discussing the situation, and at one point I finally made the call that we were going to have to recommend receivership instead of a certificate, because what we had been learning through our conversations with DNR and customers, that we did not believe that you would be able to properly operate a utility if a certificate was granted.
Okay, I have no further questions at this point.
Thank you, Mr. Blevins. Are there any questions from the commission? I hear none at this time. I have a few bench questions for you, Mr. Gately. Now, you said you went on several site visits, is that correct? Or
I
visited several wells?
visited several wells on one visit.
Okay. And even though you did not step into the well houses, what was your observation in regard to those well houses?
I will characterize my site visits as much more limited than someone who was doing an inspection. But what I saw were very simply constructed well houses that did not appear to have received much maintenance. They didn't appear to be recently painted. Some of the roofs were clearly in distress. I don't recall during my visit if we saw one that had some of the other documented problems that we've seen in some of the photographs.
You indicated just a minute ago to Mr. Blevins that you were not sure when exactly you made the determination to shift the PSC staff focus from assisting Mr. Blevins with obtaining a certificate to recommending a receivership. You may not remember when, but do you remember what it was that tipped the scale?
I would characterize it as an overview of the evidence and the repeated problems that we were seeing. I mean, during our investigation, customers learned we existed and started reaching out to us. So we kept receiving communications from customers about when they would lose service. We had one that we were considering, I might get the terminology wrong, but some kind of emergency order from the PSC, because my recollection, at one well, they were without water for 2 weeks. At some wells, there was work going on that caused DNR concern, that we kept seeing operational type of problems. It just didn't seem like a safe situation to me that could be remedied easily by a company that had the capabilities to properly operate the utility. And I don't remember there being a specific circumstance. It was more of a series of discussions with other staff members.
Now, given that you indicated that most people have not even heard of the Public Service Commission, much less know what we do, what is it makes you believe that Mr. Blevins was operating illegally on purpose?
That has to be my presumption when I begin these investigations. The companies that choose to do business that is otherwise regulated for whatever reason, there are lots of them. There's lots of oversight boards and commissions and such. it has to be my position that someone is operating illegally on purpose when we start these investigations. With Mr. Blevins, we met with him, we described the situation, offered an educational opportunity, informed him that if he wanted to get a certificate, the proper thing to do was to first acquire legal representation, because this is a legal process, that if he well, I started to say the ownership situation that wasn't clear, but I don't know if we had reviewed the property tax records to show that he had not recorded ownership of a lot of these with the county. I don't remember if that was part of the initial meeting, but that was part of some of our questioning to Mr. Blevins when we found that he had, for some reason, chosen not to record with the county government that he owned certain properties. You can't provide safe and adequate service if you do not have legal access to service a well. So when customers had told us that they had bought lots and believed they owned the well that was on the lot, it made us be concerned that, well, okay, does an easement exist? Is there a way for the water provider to legally access that well? I've gone off track a bit. Sorry.
You were fine. You answered my question plus some. We've primarily talked about the three systems, the three public water systems of Charity, Misty Mountain, and Rolling Hills. Now, you indicated there was a public information meeting that was held. Was that just for customers of those three systems, or was that for a larger customer base?
We sent letters to all the customers that we received contact information from Mr. Blevins. We had exchanged contact information during that meeting, got his email address, exchanged some emails. I later learned that one of the systems we did not receive addresses for those. It was a limited number of customers. But we wanted to hear from everyone that this entity was providing service to.
Have you received, has the commission received complaints from customers that were not a part of those three systems?
I believe so. I did not try to keep track of that level of detail myself.
Did the commission or did the commission staff receive complaints after the filing of this case?
Yes.
Is the commission staff continuing to receive complaints?
I think that's an appropriate characterization, yes.
You indicated that you were contacted by DNR with DNR's concerns. What exactly concerns did DNR express to you?
They had a situation, they believed, where customer safety was in jeopardy, but also that it appeared to be a company that should be regulated by the PSC. I and my predecessor do what we can to have meetings with DNR staff, explain what we do. I had one with one of the DNR regional offices just last month, so that when they encounter a situation like this, they know to refer them to us for investigation.
At two different points during your testimony here today, you talked about Mr. Blevins' capabilities, and at one point you said that he was lacking the infrastructure, and at another point you said he had insufficient resources. What do you mean by that, or by by using those terms? What do you mean?
But I'll contrast his situation with another company that we regulate. I know of one company in particular with slightly more customers that still keeps track of everything on paper, issues paper bills. That company has an owner, has another person, I believe is a relative, that assists with office tasks and billing, and they have a couple other folks who can step in when something needs to be done if those folks are busy or unavailable. Those customers always have someone who will answer the phone. There's a 24-hour service line. None of that exists based on the customer's experiences they've relayed to us with Mr. Blevins. It's never a good idea to only have one copy of customer information, billing records, that sorts of things. If there was a fire, for example, Mr. Blevins would have no idea who has paid, who has not paid, and I witnessed customers who were paying for multiple months at a time. Customers have told us they had paid ahead for 6 months just as wrote a check. All those kinds of records would be destroyed with no backup, no recourse for those customers, except for them having to try to file a complaint and fight or go to court. That kind of lack of basic operating infrastructure that I have seen done well, and I'm not seeing that with Mr. Blevins. The poorly maintained wells and the wells that were not repaired quickly, the situation where DNR was asking for disinfection to be installed and investigate the well to see why disinfection was even necessary. Either a company lacks the financial resources to conduct those activities to let people have decent water. Either they lack the money or they lack the empathy. I call it a callous disregard of customer safety and their health when you know you're providing water that can make people sick.
At one point during your testimony, you indicated that lives were in danger. Why is that?
The presence of E. coli in water is an indicator. It's one that we can culture readily. We can do good tests for quickly. There's a large infrastructure set up for that with drinking water and with wastewater, so that we can do these tests. But it's still just an indicator. It shows that some gut bacteria is getting in the water. But there are a host of other pathogens, some of which are routinely more dangerous to human health. And without a doubt, E. coli will kill you. It depends on which strain you get and how good your immune system is. But there are other things like Cryptosporidium, for example, that killed over 100 people in Milwaukee in 1994. Giardia. There's of course, a host of viruses and such that it's possible that could be in there, but all of those things are very hard to test for. So we use E. coli as that benchmark. When we see E. coli, we know there's at least a problem with that, but likely problems with other pathogenic organisms.
We've seen that there's a lot of these small, I guess you might call them domestic wells, that Mr. Blevins allegedly has, that are not being regulated in any way by the Department of Natural Resources. And the concerns that were expressed by the Department of Natural Resources were as to the 3 systems we talked about that they do now regulate. What is the logic behind requesting that the commission do a receivership for all of Mr. Blevins' water operations?
A water provider is required to provide that safe and adequate service. There isn't a way to logically separate that simply because a provider had multiple wells that were small enough not to fall under DNR's rules for licensing and sampling. I would envision a company that receives a certificate, if operations continued in this manner, that we would work with DNR to establish a minimum sampling requirement for that company to demonstrate compliance with PSC law and the tariff that they would receive. Without that, there isn't any way to ensure that customers are receiving that safe and adequate service. But the concept of a company being allowed to operate in a way that they should have to have a certificate, but they're too small for some of DNR's rules, that doesn't make any sense with the PSC law. And there's no minimum number of customers to be served with drinking water. And I think that, it's my opinion that that's appropriate because of the risk. I mean, people are consuming this water, therefore, there must be some kind of oversight to the extent of our ability.
Okay, we're not, we're not talking just about oversight. That's, I believe, the complaint case, and that is also the certificate case. But we're talking in this hearing about receivership. Is the underlying assumption, and if I'm wrong, let me know, is the underlying assumption that if these are the deficiencies and dangers with the systems that DNR is looking at, that it is unlikely that the systems that DNR is not looking at are operating at a different standard? Let me see if I can say that more succinctly.
Thank you.
Is the commission assuming, or is the commission staff assuming that because these deficiencies, dangers exist with the systems that DNR and the commission has looked at, that those deficiencies are also present in the system or in the wells, Mr. Blevins owns, that DNR and the commission haven't directly looked at?
Yes.
Thank you. Would you just run down with me? I've heard a myriad of different complaints spread out across the hearing, you know, not receiving water off for periods of time, high chlorine, you know. Can you just go through, to the best of your memory, the nature, not the number, but the nature of all the complaints that you're cognizant the commission staff has received?
And by received, I would include the ones we received
From
people
DNR, correct.
At the public meeting as well, but yeah.
Yeah, well, I think that would be inclusive because those theoretically were customers that were invited to be there.
Customers complained of not being able to predict or understand how much they were paying. Customers complained of not being certain who they were even supposed to be paying because they would received conflicting documentation from someone trying to collect money from them. I received complaints that I did not attempt to substantiate myself, but folks who experienced what appeared to be people who were under the influence of some kind of recreational product, confronting them at their homes, being unconscious in a vehicle, right after talking to them at their homes, generally concerning and unprofessional behavior out of folks who were purporting to be working for the utility.
Wait a second. Can you explain that? These were things that customers told you or that you observed?
I did not observe
Okay.
because they had been in the past, but multiple customers told me that a person they understood to be related to Mr. Blevins or his son, I didn't try to chase down who it was. They had several unsavory encounters to relay. The customers complained about a lack of certainty that they would be able to even sell their homes because of the inconsistent service or lack of service or unsafe service. Customers complained about the speed with which DNR and PSC were addressing the situation. They complained about like the situation which was mentioned to us or mentioned to me at the public meeting where a customer had to dig up the line themselves that they had heard existed that would allow a connection to the public water supply, the county. That their water provider didn't even know that it existed or where it was upsetting to them. And I've heard multiple explanations of that, but that was a complaint that we got, that they felt they were having to go out and improve the service themselves. When they were told they were under a boil order, there was no effort to give them bottled water or some kind of alternative. There was not what customers expected how they would be treated by a company. The safety concerns that DNR relayed were obviously the most concerning for us. With the contaminated well, they had approached Mr. Blevins. This must be corrected, and nothing was done. And then it's my understanding that there were also other wells that experienced bacterial contamination, which suggests to me the potential for either multiple wells being constructed in a substandard manner or the particular aquifer they were in is contaminated and therefore disinfection may be necessary on all the wells. Pulaski County is an area with what's called karst topography. It's relatively easy for surface water to enter groundwater, and there's lots of situations where wells are disinfected for a reason. That created concern out of the customers that if some of the wells, which they had understood had tested positive for bacteria, then multiple wells might also test positive for bacteria, but they didn't know. At the well that eventually physically failed, I received complaints from customers about debris entering their water or entering their house through the distribution system. The faucet aerators were becoming clogged with sediment and debris that they described as looking like mud. The overall condition of the well houses that we saw is certainly going to be something that folks complain about. Sometimes appearances don't necessarily say that it's definitely an unsafe situation, but in this case, what customers brought to us certainly suggests that if it's not unsafe yet, it could soon be. There's a reason you secure a well, and there's a reason you have it safe for folks to come in and work on it and maintain it. And then we also received complaints from customers about outages and low pressure.
Other than a boil warning from DNR, were customers, are you aware of whether or not Mr. Blevins informed customers of some of these potential dangers as they were discovered?
I don't know.
Okay, thank you. Those are all the questions I have for you. Are there any questions from the parties based on bench questions? Mr. Blevins, do you have any questions based upon my questions?
No questions.
Thank you. Any redirect or any questions based, first of all, any questions based upon my questions from staff?
Well, I have some questions,
Are they redirect?
mostly.
Okay. Go ahead.
Okay, thank you. So if a person, a company, a utility, well, I guess a utility offers water to the public and charges or bills the residents, people for that water, people that use it for that water, and they're not licensed by the PSC, they're violating the statute, correct?
In this case, that's our position
Okay.
with Mr. Blevins.
And the PSC isn't out looking for violators. They're not out searching for utilities, unregulated utilities that might be billing people for using the water.
Not only do we lack the resources to pursue such an effort, I don't have enough people for that sort of thing. If folks are receiving safe water and they believe that they're paying a reasonable amount for it, they're not coming to us with a complaint. Our involvement generally only increases costs for everybody.
So if you get a
So there's-
complaint, I'm
there's-
sorry.
There's not a reason for us generally to go out and start beating the bushes looking for folks to regulate. But in our situation right now, we're certainly complaint-driven or referrals from DNR usually. Occasionally, I'll receive a referral from a company that is certificated to serve an area and learns of someone operating illicitly.
But for the most part, the complaint comes to you and then the complaint comes to the PSC staff and then the PSC staff goes and does something.
Yes.
Okay. But an unregulated utility is not supposed to charge rates under the law that they're supposed to charge rates that are filed and approved by the commission. Correct?
There are situations where folks recover costs by charging company or customers where they're only recovering their costs that they paid to another water provider. They're not operating for gain. They're not disconnecting people. They're not charging late fees, those sorts of things. They're only recovering costs associated with usage through, they have one large meter themselves. Those situations, generally speaking, are not subject to PSC regulation. In this case, someone operating in the manner that Mr. Blevins is operating under, yes, they would only be able to charge rates that are approved through a tariff.
Okay. And that would be because they're licensed and regulated.
Yes.
So you testified about the public water system being cost prohibitive to run that water to some of the houses, some of the neighborhoods, that it was cost prohibitive. Can you explain why? You talked about the
When
terrain.
you're trying there are no lines that are close by, that are easy for folks to simply make a connection to, beyond that we know of, beyond the line that Mr. Blevins already took advantage of to connect some folks. In order to move the water from a supply to these neighborhoods, you would probably have to have, and I haven't tried to consult an engineer on design on this, but looking at the terrain, you'd probably have to have multiple pumping stations. You'd certainly have to have miles of new water line laid for a very small number of people. That means it costs a lot of money, and that effort then in the public water supply's mind, to serve a few folks over a long distance away and to incur all those costs that would then have to be borne by all their other customers, they did not view that as a situation they wanted to get into, and really it didn't make any sense. It's a lot cheaper to fix the wells that are there, install disinfection, and maintain those wells than it would be to spend hundreds of thousands or millions of dollars on getting water from a long ways away.
Okay. And you said you had visited Mr. Blevins in his office. Did you see his records?
I saw some. I did not attempt to go through all of his books.
And what did they look like? Were they ledgers, paper, computer records? What?
The records that he showed us, it was more, our discussion with him was more about the situation in general and what the PSC was. He happened to have some on his desk that he briefly referenced, but two customers showed up while we were there, and he was referring to his ledger to reference what he believed should be charged. So I did see some of that, but he also had a secretary who had a tablet, and that's how we started exchanging emails and such. So I don't know for an absolute certainty that some of the records are not on that tablet, but when we asked Mr. Blevins for information as part of discovery among the complaint case and the, all three cases, what has been given to us is copies of handwritten records.
You said you were trying to figure out what properties Mr. Blevins owns. Were you able to tell easily what properties he owns, what wells he owns?
I have folks who were looking into that, so I'm relying somewhat on what they relayed. But no, the county clearly indicated that some of the wells that Mr. Blevins was providing service from, the county said he didn't own them through their property records.
Okay. And so you said he owned or sold wells without recording the deeds? Is that what you had said earlier?
I don't recall, but that is a correct characterization of what I believe some of this was, because Mr. Blevins had showed us documents that for some of the wells that he did own them, but that conflicted with the county records, and that would suggest that it had not been filed with the county to make it proper and legal.
Okay, is that a problem?
Absolutely.
How so?
If someone else owns that well, they can put a lock on it and say you can't access this. If someone else owns that well, they could attempt to prosecute someone for trespass. If someone else owns that well and they are the ones who are providing service, and someone else approaches you to bill you and they claim they are also providing that service, then the customer has no idea who to pay.
Would that be a problem for the PSC or a receiver or utility to?
The receiver is going to have to straighten some of this out. It's my understanding that since we started this effort, Mr. Blevins has sold some wells. I haven't seen the documentation of that myself. I don't know if any of those sales have been properly recorded. When we have a complaint, we have to figure out who the responsible party is, and that has been somewhat difficult in this situation, except that Mr. Blevins has said that he is the provider. That he does have clear ownership of some of the wells, but untangling some of these extenuating circumstances is going to be the responsibility of the receiver when they're trying to dispose of this and get it in the hands of a proper utility.
Okay, so really being the provider isn't necessarily being the owner of the wells that you've as you've come to find out?
In this situation, yes.
Okay.
Did the number of complaints that staff received, and when I say complaints, I mean in the general sense, not necessarily informal or formal complaints, complaints received in-person conversations, phone calls, emails, is this what triggered an investigation into Mr. Blevins' system? Along with,
Along with DNR, certainly.
okay.
Yes.
And once staff's focus shifted from the CCN case to filing a petition for receiver, did staff feel the need to act relatively quickly due to the information that we had gathered at that point?
Yes.
And due to the difficulty locating information in records in this case, and also a lack of information in records, was that what staff felt was the best option in this situation, even though we weren't able to present maybe a perfect case?
Yes.
Does staff need to verify or investigate every single complaint that it receives to determine that a utility is not providing safe and adequate service?
If we receive several complaints that are of the same nature, and we demonstrate with even one of them, if it's the same complaint over and over, then that would carry through all of them. We don't have to investigate every single customer complaint to view something as a problem. Generally speaking, we try, and we do investigate every informal and formal complaint against regulated utilities.
Would you say that the water and sewer industry is unique from other utility industries such as electric and gas, and that you deal with a larger number of smaller systems?
Yes.
So it's not unusual for water and sewer staff to meet with individuals or small groups of people or families who own a company in water and sewer,
That's not unusual.
as opposed to electric and gas where, or larger water companies where you might be meeting with that company's employees who are well-versed in PSC regulation?
Yes.
Do you think that staff's water and sewer department does its best to explain the role of the PSC and how to comply with our regulations?
Certainly.
The purpose of staff's petition for an interim receiver is to protect the customers, correct?
Yes.
Our goal is not to punish Mr. Blevins, correct?
Correct.
Does staff's lack of knowledge of a system mean that it should not be regulated? If we're not aware that a system
Not directly, no. I mean, we have to have some kind of basis for why we would
right,
pursue an effort.
but just because we are not aware of a system doesn't mean that it would fall under PSC jurisdiction,
Correct.
even if that system has been operating for decades.
Yes.
Is it unusual for staff to identify or discover or to have brought to our attention water and sewer systems that have been illegally operating?
I would not characterize it as unusual. There are a few a year. Most of those, the outcome is that they change their behavior to no longer fall under our jurisdiction.
In order to indicate a safety concern, do we need to determine that a specific person experienced skin irritation, for example, from chlorine in their water? Or is it enough to just know that the risk is present once a certain level of chlorine has been detected?
I would characterize it as knowing that unsafe practices are the norm for a company is enough. I don't have to see myself the chlorine results that were a risk at someone's tap if it has been explained to me that someone routinely engages in activities that are likely to put a customer at risk.
Would your response be the same in relation to E. coli or other bacteria that might be detected in water?
To a degree. With E. coli detection, that's a very firm example of a serious problem, but that's not necessarily created by the water company, but it dictates a response.
And that's why water testing or sampling occurs, right? To prevent or limit harm to customers?
Yes.
Right. I have no further questions.
Staff have any more witnesses to call at this time?
No.
Mr. Blevins, did you want to testify on your own behalf?
Yes, I would.
All right, I don't want to break up your testimony. This seems like a good point to take about a 15-minute break. It is currently 9:51. I'm going to go. Why don't we come back at 10? Let's come back at 10:15. So we'll recess till 10:15. Let's go off the record. And Commissioner Kayla Hahn has just joined us in the courtroom.
Judge, before we begin, I just had a question. This is Paula Hefner, the court reporter. I didn't get the name of the attorney assisting Miss Kerr. Is it Miss Aslin, Aslin?
That is correct.
Okay, and your first name?
First name is Casey, C-A-S-I.
Thank you so much. I apologize for the interruption.
No, please, if you have a question, I want an accurate transcript. So if you have any questions at all, please feel free to interrupt me or anybody else.
Okay, that's it for now.
Thank you. When we left off, staff had completed their case in chief, and we were moving on to Mr. Blevins. Mr. Blevins, you indicated you wanted to testify prior to the break. Is that still the case? Okay, would you please step up to the witness box? You can bring whatever notes you need with you. Mr. Blevins, would you raise your right hand to be sworn? I know you were sworn in yesterday, but just out of abundance of caution, do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Okay. Since you are your own witness, generally we don't go with the farcical, where you answer your own questions, but what this is going to give you an opportunity to do is you can kind of just go over in narrative form what it is you want to tell the commission in relation to this receivership hearing. In regard to that, I'm going to caution you again not to use any customers' actual names or identifying information. And if an objection is made while you are giving your testimony, please stop talking and give me time to rule on the objection, okay?
Okay.
All right, if you would like to go ahead and let the commission know your side of the story, please.
Okay, I guess I'll begin. Normally, my name is Leon Travis Blevins. I'm almost 80 years old. I've retired three times. I retired military, veteran of 20 years, and I'm on Social Security, and my wife is the same. Both of us have a lot of medical problems, so I'm not going into any situation, either past or future, that is going to cause a problem for anybody, and especially my wife and I. The wells that I own these wells in three different ways. I own some of them by deed, which is fee simple transfer of property from one owner, which is the grantor, and to me as the grantee. If I dispose of those properties, then I become the grantor to somebody else. Now, I acquired also some wells by contract of sale. And the reason why they were done by contract of sale is because there was a problem with maybe the legal description of the particular well site, or there might have been some problem or discrepancy in the easement, either in the well site itself or the lines that are distribution system that are in the easement along the roads and in the properties. The people that I acquired these wells from are very short. Don Becker, he is a contractor. He builds houses and constructed some of these wells through other contracts, well drillers, etc. 20-some years ago. Also another contractor, Jim Parsons. Same scenario as far as the constructing the wells or owning the wells or having them built for a particular purpose of providing water. The most recent one acquired was from Mark Rowden. He is a contractor, but from him I had no contractual agreement. I simply wanted the deed. That deed is in possession. Had it dated 1 December, and there are 4 wells in that deed. I know that through all of this process, there's some confusion about what I own or don't own, but I have no confusion whatsoever of what I own, and I can show whatever documentation that someone would want to see to let you know what my interest is in that particular well or system. There's also one other individual, as Kevin Rowden. I kind of forgot about him. Not that I forgot about him, but that is a recent purchase. That's a handshake. And there's about 2 wells, I think, in reference to that particular agreement, and that's over on the Corvair side. But those wells have been sold. They've been sold in the same manner in which I purchased them. In other words, they were mine to sell by whatever reason of ownership, and I've transferred those out. When I've started gathering wells, not gathering them, but acquiring these wells, I was in some places asked to do that. I was asked to take over these wells, or maybe offered to take over the wells. I'd like to go back to originally, Mr. Don Baker was the first well sites that I acquired. I worked for Mr. Don Baker for a couple of years, and one of the things that I did was take care of these wells. These wells were in not the best of shape, and they're not in perfect shape today. But he had confidence in what I did do for the wells. I improved them even when I was working for him. Made sure that during the winter time that if there was a call, I was the guy that went and took care of that problem. Nobody had to show me how to do it or tell me to do it. I did it because of responsibility. I'd have in the well idea of another reason why I really acquired these was not to dodge any laws or anything like that. It was to create something that could be returned to me and my wife on our retirement. We've been retired, and I still work. I have to work every day. I had a total of 24 of these wells. And if you'll notice in some of the identification of these wells, you'll find the MW01 clear on up to MW24. Right now I have 8 wells left. And those 8 wells make up the 3 public water systems that the Department of Natural Resources has recently activated, the Misty Mountain, the Charity, and the Rolling Hills. Those are the 8 wells in total. There's particular problems with some of those wells, but there are circumstances in reference that has not been addressed in any of the other investigation type information that we've been receiving through these investigations or through these witnesses, etc. I'd like to go over a few of those, just briefly though. Let's say that the wells that are non-operational at the present time, one of them is what we call a concrete well, which is out on the Charity system. It was taken out of operation. I took it out of operation myself some time back, but we connected it up to the other Charity wells. There's 2 Charity wells on that one, or 2 wells on Charity Road that we connected so that the concrete well that serviced the Covenant properties would be all covered by those 2 wells. Now, individually, my anticipation is to continue to get that well repaired by an appropriate person, which is Rick Guile, which is Rick's Pump Service. Also, the other well that is non-operation, obviously, is the Topo well. And since that's on Misty Mountain, different area. But since we talk about Topo so much in this process, that was a difficult well to deal with for the DNR and also for myself. I'd like to clarify a few points maybe there from all the other testimony that's been talked about in reference to that particular well. The well itself tested with an E. coli, obviously. So my attempt through the DNR was to find out why that particular well is coming up with E. coli. As we would do the investigations, we would eliminate certain things. DNR talked about the pitless area. There was nothing wrong with the pitless area. I inspected it with equipment, videoed, and etc., and found that it was not the pitless area, but was a little bit below that, and that was on a line. It's on a water line. That water line is 400 feet long, at least. In fact, that well, I think, is 440 or 460 feet in the ground. The weight end of it is that far, which is the pump and the motor. It hangs on that pitless, but there was nothing wrong with the pitless. We kept investigating. I understood at one time that there was a connection to the public water system, Pulaski County. I inquired about it early on, but could not receive any good information as to where that line still existed and where it came out at the well site. We finally, after doing many things to investigate why we had E. coli there, and everything it didn't solve the problem, because we would do shocking, which was directed, and then later it would come back with E. coli again. I finally got to talk with Don Baker. He was actually in Florida at the time, and he had just returned. And I come to find out that that particular line, or that particular property over there, was initially hooked up to the Pulaski County water district. But it was put in or connected with a line that Don Baker's brother had actually installed in the ground, which was a 1-inch PEX line. Nobody could remember 20 years back as to what happened to that particular line. and also in reference to that particular well. We understood that all of the residents at that time did not like the Pulaski County water supply. They wanted to stay on the well or have a well water, so that was done. But when we did find out that there was still an existing line, then I hooked it up myself. The line has never been dug up there was some testimony the line was dug up. What was dug up was a different line that was a valve that actually turned the well water off when that particular water was from the county would be coming into the distribution system. It worked after we discovered at this late date. I didn't know this in the beginning, had no idea of the county being collected or connected to that particular well in the beginning of 20 years ago. Didn't know it. And neither could Don Baker even remember part of that, but we sat down and talked extensively about it, and come to find out he remembered who put it in, which was Don Baker's brother, so I got a hold of him, and we determined that he remembered there was a line there. So we went ahead and went down to the county, confirmed that there was a meter out there. I said, let's hook it up and see what happens. We hooked it up. I think was one question about what the deposit was. I believe it's $300 deposit, but that's not really an issue to me anyway. So we hooked it up, and water started coming into the well distribution system. So that solved that, and that's what's operating even today. We're trying to get maybe the public water system there to just take over that line. They don't want it. My understanding is that they don't think that line would be sustainable for their period of time, I guess. But anyway, DNR is talking about plugging up that particular well. I would rather see the well repaired, but if they decide that needs to be plugged, that's probably what I would have to do in order for the residents to get back on a well. They'd probably have to drill another well. I don't know. I'm in the retirement mode. I'm ready to not do this so much. So I'm not here to cause anybody a problem, but I don't want to go out of this process of obligations and fiduciary agreements that I've made with other people. I want to go out equitably. I'm not even opposed to receivership, in my opinion, but I think it would be way, way too expensive for clients out there to pay the expenses that would come about with all that, especially if I had to gear what I do into the FSC requirements. I can't meet those requirements. And it's way too late in the game for these wells to be brought up into that type of situation, but there are other solutions. My solution would be for the wells to be incorporated into a homeowners association. Doing that, I've already arranged for an attorney to prepare all the documents and make all the reports to the Secretary of State and et cetera. But there's a lot of work to do an HOA. I'm sure you're probably familiar with it. I don't know if you are or not, but there has to be agreements by the people that use the water in these wells. But that can be arranged also. There are choices that they would have. If they didn't want to be in the HOA, they could drill their own well. At the present time, the cost of a well for one property, I would give you some numbers that would probably be up in around $25,000. That's a tremendous amount of cost in relation to 20 years ago when that same well could be put in the ground and operating for maybe $8,000. That's a big increase. And then 20 years ago, when that was put in, okay, thank you. The cost or the fee that was being charged by these contractors that owned the wells at that time was like $30, some of them $25. Today, the cost of that, from my viewpoint and from the agreements to furnish water that I try to get from each one of these customers that want the water, is $55. There are other incentives, though, in this agreement to furnish water. They can pay a discount or prepay it if they prefer, which I was asked to by many of the customer people, clients, if they could pay a year at a time or 3 months at a time or 6 months at a time. I provided that to them at a discount. Also, they could pay by automatic deposit. I've only got 2 or 3 of those that actually do that, but most of them just pay monthly. I've never had any real complaints about the money or the charge until at such time when DNR got involved and also the FSC got involved, the staff I'm referring to. The DNR, when they activated those particular wells, created expenses. My determination was about $1,000 a month. That's $12,000 a year.
Can I clarify something real quick? When you say FSC, do you mean the PSC?
I'm sorry. That you're correct. That is the PSC. I'm sorry.
Thank you.
Public Service Commission. Yeah. And mostly I'm referring to the staff. That's the people I know that I've met with, or they say they met with me. So my testimony is that 20 years ago, if you paid $30 for water for a residence, and now it's $55, that increase over 20 years is not much over $1 a year. I don't know if that equates or not, but when you, to somebody's belief or whatever, but when a well costs $25,000 to put in the ground, and that's probably a horse and a half, and the wells that I have are 5-horse wells, 3-horse wells, and very few of them are 1.5 horse wells. But those have all been sold. They're individually, and they can only handle 2 or 3 clients or 2 or 3 residences getting water. All of these wells were taken in good faith for me to improve those. And to date, since I've started with these wells and agreements with the contractors and et cetera, they had confidence in me to go ahead and do that. I've improved each and every one of them in some way or another. And they probably still need more work. I'm real sure that they do. But I do not have a staff. I do not have employees. The young lady that has been referred to as an employee is what I call an adopted granddaughter. Not legally adopted, but her father and me previously had business relations, and I've tried to help that family as much as I can. And she does come in and work with me. She helps us kind of maintain and run a store, an antique type store or whatever. And something that my wife likes to do is handle antiques and so forth. And she's not paid a salary, but she does help in everything that I do. I do pay her, but she also earns a little commission when she makes a sale or something of that nature. She is not a employee. She's independent, and she doesn't have any particular hours that she comes in. She works on her own, but she is familiar with a lot of things that I do. I've had several businesses in my lifetime, even in Pulaski County. But back to this particular receivership, okay. At the present time, I've invested funds in improving these wells, and right now at the bank, and if I needed something done, I would go to the bank and draw on what I call a line of credit loan. I've got about $40,000 on that line of credit, which has been used, but I still pay it monthly back to the bank. Those are financial situations, and what I think it's been said that I'm not capable of doing this or doing that. I've went for the last, ever since 2016 with these particular wells on my own. I didn't ask for any help from anyone else. It was mine. But the incentive there is to create the wells because of the relationship I had with these contractors. I've actually, with Don Baker, I was a partner with Don Baker in years back, constructing homes, and Don Baker's probably built 1,000 homes. I owned a real estate brokerage firm at that particular time, and I probably sold more than half of what he's built. In my previous years of dealing with real estate and construction, etc. Again, I'm retired, but I retired from the military in 1981. Right here in Pulaski County. But I've been associated with these people, and we have good relationships. The last well that I actually upgraded is the Rolling Hills well. And where we upgraded it, it was about $17,000. That's still owed. Not all of it, just part of it, because we pay Rick Guile, who is our pump guy, we pay him monthly, and this is by agreement with him. At one time or another, he was going to purchase these particular wells for his daughter, which we were going to sell them to him. But it turned out that there was too much involvement for Rick Guile in reference to the Department of Natural Resources. But he's not opposed to DNR, but he didn't want to deal with it at that particular time. He's a busy guy, he's an honest guy, he's truthful, and he does not overcharge anybody. Then that's the reason I do business with him. I will not do business with the pump companies that are around. I'm not going to mention their names, but I wait for Rick Guile because he knows, and I've talked with him on several different occasions about the wells that we've got. Let's see. The CCN, that Certificate of Convenience and Necessity, I admit I had no idea what a CCN was when they come in my door, which was wanting to know. I was cooperative with them, and I understood that I had to submit this application for a CCN without really understanding why I needed to do that. But I very quickly, after receiving information that I was to provide over 44 some data information, which that data information was not available. And it had to be created. Everybody's talked about it already in this whole process when they say they can't determine what I own or don't own. That was part of why I took on this job of taking these wells from Don Baker, Jim Parsons, is to help get all of that straightened out in the proper manner. I'm the guy that they called and wanted to fix it. I'm the fixer, I guess I'm trying to say. I've done it all my life. That's what I do. But I do it honestly and truthfully. There's no other way to do that. And and do it proper. I admit that, like the topo well was a problem, and really it's still a problem, but just plugging up the holes really doesn't solve the problem. I believe I know where the problem is when I discovered that, or myself and Rick Guile discovered that particular casing around there was all cracked. That's where I think the real problem existed then and still exists now. But that well is not into operation. So there's been so many different things set up in this whole process here that it's kind of hard to keep it in one line. But I want to go back to this receiver, I guess it is. A receiver, if a receiver comes in play, then I foresee a lot of expenses that's going to happen to these people out here that are now complaining about increases in their prices. DNR caused some of these increases, which I equated to you at $1,000 a month. This last testing was $610. That's just for the testing. So there's other expenses already that has to be paid. So it's going to be over $1,000, but over a year's time, I don't think it would go over $1,000. I'm not objecting to the DNR. I think it's necessary. And it would be good for whatever structure comes about. I don't believe this receiver would have that particular thing in mind about these clients out there. I think I have a responsibility to protect them as well as myself, and as well to protect as way I can with the people that I made these agreements with or I acquired these wells from. For those people, I owe no money. There's no debt to them because I've already paid that debt for the acquisition. But I didn't. I've spent a lot of money just improving them and bringing them up to where they are today. And I anticipate that at the present time, there needs to be about $5,000 to $10,000 more spent on some of these improvements, or some of the problems that I know exist with these wells right now. But I wouldn't want to intermingle all of that into what's going on today. That's something that's going to have to be taken care of, and but it not only, we're down to the point, I guess, with just what DNR has activated in 8 wells. That's where I'm at. 8 wells. If an equitable solution is not attainable somewhere, then I think it would fall apart. I think the system would fall apart. These wells, especially the ones on Charity and the ones on Misty Mountain. Now, the only single well that would qualify under the DNR guidelines of 15 connections and 25 users or is the Rolling Hills well. That one has 1 well and 19 connections. And that brings my thought up to some of the complaints that have come about here, even the ones that I have read yesterday and today for the first time. I've not received any of those complaints other than 1 or 2 of them there, I believe, and I've already answered to that particular complaint that was on some of the previous submissions that I gave to the commission, you all. I submitted that the other day when we talked about having the answers to the receivership or the complaints made by the staff asking for a receiver. I think I have answered all that. I assume that you all received all of those documents. I personally delivered them to your mail activity downstairs.
I don't know what documents you may have provided to staff. Now, are you referring to the answer that I ordered you to provide?
Yes, sir.
WC case? Yes, that was filed. I have that right in
Okay.
front of me, inclusive of the various attachments.
Well, yes, and that the reason I brought that up is because the complaint, there was a complaint in there, but I believe I've answered that complaint. All those other complaints that I've seen either by email or just mentioned or etc. I've not seen before until yesterday or today. Yesterday, actually, in those exhibits. I've not seen those before, so no opportunity to reply to them, but I can reply to them now, I think, by saying that I think I recognize some of the complaints, especially those ones that are lengthy, that one would have come from one of the water users that has owed money for water for several years, not months, but years. I think the balance is probably over $4,000 or $5,000. I've never threatened any of those clients out there in any manner. It's not in my character to do that, but it is in my character to try to talk with them and come to a resolution of what's going on. And I've heard complaints about threatening to cut their water off. In that agreement to furnish water, it says specifically, if you do not pay your water usage fee that was agreed upon for over 6 months, then I, as the owner, would have the right to disconnect that water and permanently terminate the water from that residence. I have never done that. Even though it's in that writing, it's not in my character to cut people's water off either. I've never cut people's water off for any particular reason, even non-payment. I've never threatened to cut it off, but I have indicated that you need to, and that goes back to the billing. I don't do billings at all. I don't bill you out $55 every month on a piece of paper, because there is no meter. There's no meters, and never has been for 20 years. And so I don't bill it out, but I do send out a notice after 10 days of not receiving the water payment. And it's important that we did that because we have to pay the expenses. Now, totally, in this whole system, even with $55 a month, if you would count 100 clients out there, that's $5,500 a month. Is that correct? If that would be my calculation. And that's quickly taken up in electric fees. With so many wells out there, every one of those wells are on a separate meter. So I can tell you right up front that the electric bill to Laclede Electric, for example, has been like $1,500 a month. The electric bill over at the Dixon area, $600 a month. There's $2,000 in just electric services. We haven't paid for all of the maintenance that needs to be done on a daily basis or a weekly basis or a monthly, or even in a situation where a water leak does happen. I've got 3 backhoes, but when a water leak needed repaired, I'd take a backhoe out there and fix it. That's what I did. I don't know why it was determined that I don't fix leaks or something or don't perform maintenance. The investigations that went on, in my particular opinion, was not very well conducted, lackadaisical in nature, in my opinion. It was not investigated thoroughly enough to find out really what the situation was, especially with the complaints. I've heard complaints that I've never heard before. And I think what prompted these complaints, in my opinion, were the involvements. They finally had somebody, I guess, maybe because of their frustrations, whatever it may be. And I can understand that they would have frustrations when we had to raise the prices because of the cost of DNR, for one. We had to raise the prices in the beginning because the people I purchased these wells from were tired. They didn't have the time to go make these collections or anything like that. So all of a sudden, the people that are not paid for years, I provided a solution to that for them, and the people that owned these wells prior to me, and for also the people that were using the water. I don't think it was fair that they just not pay it and let them go. So I created a past due account for them to pay whatever they could afford on a monthly basis to take care of that, their own responsibility. And in one case, just to give you an idea, the individual user would owe, I think, maybe $1,200 or so, and what they can afford to pay was $5 a month. No interest, okay, that's okay. But you had to keep your current payment up to date. At that time was probably $45, I don't know. So we just carry that on through. There's more than one or two or three or four of those kind of situations. And some of them that were, almost every one was behind when I first took all of these wells and or acquired them. I didn't take them, but like for Mr. Mark Rowden, who was the seller of those 4 wells out there, he simply told me, he said he does not want to get involved with trying to collect money from those people for those wells, but he obviously had been paying the electric every month on them with no income. So he asked me to take them over. I did that. I improved them. Right now, there's those wells being 20 years old. Would you imagine that maybe the pumps and the motors right now are kind of in the area where they're going to need replaced right away, here pretty quick. But if I do that, which I've already committed to do that, then when I convert these out or sell them out, I'll get my money back. It would be equitable for me to do that. And even with going to a homeowners association, I provided in that document that I provided in that report how they could pay for that. That's equitable, in my opinion. They can either pay it in cash, let's say. That's an option. Anybody has that option. Or they can just continue to pay what they're paying now. But at the end of a certain period, they would be already in the homeowners association, no longer have that debt to get there, and they would be clearing back into $20 or $25 a month that the HOA would probably be charging at that time. Even in the beginning, when it's set up, the HOA needs to collect money in order to take care of expenses and take care of the wells. How much they collect depends on what really needs to be done, etc. I understand also that people that use these wells may not be familiar with an HOA, but that's a corporation, and it's run like a corporation. And they own the wells. Everybody in that HOA would own that well. They can determine and determine how much of that fee, even on a monthly basis if they wanted to. They can do whatever they want. They're not subject to any of the PSC guidelines and rules because they are activated as a public water system. They would be subject to the Department of Natural Resources and all of their guidelines, which I think are good guidelines. I don't object to that at all. But the HOA is a non-profit organization. Non-profit, it's not for profit. And if anybody thinks that these wells are for profit at the present time, they need to step in my shoes. They'll find out that $5,000 a month is not adequate. Of course, I don't do that now because there's only 8 wells left. So I'm trying to get this equitably finished. My job was to take these wells, get them in a good operating position, like with DNR especially, and do something else with them. One of the main goals was to put it in an HOA even from the beginning. I wouldn't own the wells at that point, but the HOA would. And they have a board, just like everybody else is set up in different corporations. That's who governs that nonprofit organization or the homeowners association. The just check my notes here if I could, please.
Take your time.
Again, I think that the complaints that seems to be a crutch that some of the investigators are using are unfounded, or they're motivated by something else. And like the example I gave you, there was a mention also that same person that I send out people to collect money. I do not do that. I have never done that, ever. If there's anything to do with money, I do that personally, and I try to do it without demanding anything, but being reasonable about the whole process. And I think I've been more than reasonable with all of the clients that are out there. And if you actually investigated and talked to enough people, I think you would find that what has been presented in this investigation process is, in most cases, erroneous. The case of Misty Mountain especially. There's a client up there that every time that we went, like to the Topo well, if he was around, he had to come in and get involved with it and take pictures. Don't mind that at all. But when they begin to create something that is not there or interfere with the people that I had there, I've got to say something to them. And I did. Not in my character to throw somebody off the property. And physically, I couldn't do it anyway. And I wouldn't do that, but I'd asked him to leave more than once. And he absolutely refused and just got more belligerent and started, in my opinion, telling untruths, creating something. I've heard a point where maybe somebody's seen me put something down a wellhead. Why would I do that when I drink the same water? That don't make sense to me, but I don't know why somebody would actually say that, other than the fact that they really don't know what they're looking at. I've heard comments that wellheads have froze up. Wellheads don't freeze up. There's no water up there, other than through the pipe and up to the line that comes through the pitlets where it hangs. A lot of those comments like that need to be investigated a little bit further to find out really what motivated it. What motivated them to say things like that? I think you'd find it's unfounded in most cases. But in my position, if I would have been notified or provided with that particular complaint, I would have answered it, and have answered it honestly and truthfully, whatever it is. And I've done that with the ones that I have been notified or been told about or even provided. And in writing, I've provided that in its entirety. I don't know, with all the testimony that has went on here, I'd just like to maybe close this out and let you know that I'm not here to fight with anybody. I would like to resolve the whole situation. I do not, I'm not happy with the way the FSC conducted. I'm sorry, PSC. Staff conducted whatever they conducted as an investigation. Not happy with that at all. But I understand where you might be. So I have a not a resolution, but a solution to it under the HOA guideline. I would like for you to at least consider. It doesn't mean that you have to do it, I'm sure, but I did all of this in good faith, and I'll stay in good faith. I'll answer any other questions anybody may have, honestly and truthfully. I've been with my wife for 66 years and married 62 years. She must have had some confidence in me to keep me around that long. And so my character is not what I've heard in these proceedings. I want people to know that. I don't think I've made any real enemies, although I guess everybody does once in a while, but not intentionally. I do not avoid the law. I try to stay within the law, try to do what is necessary to do, not only just for myself, but in this case, with the receivership, I believe would be a real mistake, not only for me personally, because of my involvement with what I wanted to do with these wells. I feel like I wouldn't be able to do that. So it's not equitable. And it's not equitable, in my opinion, for the people that use the water. Because if a person comes in and says they're the ones that take care of this, they're going to have expenses, and it's going to be a different story. It's a different progress with these clients. That created not a good image for me personally, because it's being taken away, I guess. I'm not really sure what a receiver is. I'm not sure that there is a receiver that would even accept these wells, in my opinion. I don't know. But if that would be the solutions, I wouldn't object to it. But I would ask it for all of it to be equitable for all parties involved. I think maybe that's about where I'm at. I just wanted to express why I did that, and or what I do. It was not against the law, to my knowledge. Those wells have been operating for 20 years. I just tried to continue on, get them improved, and get them into a situation that that they were needing. Even the contractors, the contractors did not want to spend more time, more money, etc. But I was willing to do that. And I did. I've done that. I just told you in my testimony here that line of credit, 40,000, I still owe that. If I can't pay it with normal procedures or something equitable, then what does that do to me? Is that what everybody wants? We've got laws that says when you can't pay a bill, you file bankruptcy. I've never filed bankruptcy in my life. But if I get forced into that corner, I may not have a choice. And I'm not saying I'm filing bankruptcy. I'm just telling you where my thoughts are. Receivership, in this case, I don't think it's good. I don't know how else to say that. I think I'm finished. I think I've said what maybe my point of views or my testimony. I'd be glad to answer any questions that any of you might have.
Thank you, Mr. Blevins. Any cross-examination from the staff of the commission?
Yes. Thank you. I have several questions and kind of here and there, so just bear with me. Now, when we talked, when the DNR witness was testifying, you remember talking about your licensed operator, Lori Jean?
Lori Jean, yes, ma'am.
And you signed an agreement with her. There's a DNR agreement where you work with her on making repairs and where she does takes care of the wells and takes samples and does all that.
Yes, ma'am.
Okay, and do you remember signing that agreement?
Of course.
Okay. May I approach?
Yes.
I handed you what was previously marked Exhibit 8. I think you have a copy of that. Is that correct?
Exhibit A,
8?
8. I do over there probably.
Okay, and is that what I just handed that to you?
This is 8?
Yes.
Okay.
Okay. Do you recognize that?
Yes, that's, Lori provided this to me as the agreement.
Okay, and that's the 3 agreements did you sign those?
Yes, I did.
Okay, and those are the 3 agreements that you signed for each of the 3 public water
One for
systems?
each public water system.
Okay.
Yes, ma'am.
And in those agreements, you agree that if you're going to make any changes or you're going to take any samples or you're going to do anything to those wells, that you notify her first before you do any of that?
That is correct.
Okay.
Let me explain that, can I?
Let me ask the questions
Okay.
first. And there were times where you've made changes to made repairs to the wells or shocked the wells without telling her first, is that right?
Well, the explanation of that is that when,
Have you done that? Yes or no? Have you done that?
pardon?
Have you shocked the wells or made changes, made repairs
Not
to the
to my
wells
knowledge, no.
without telling her first?
Not to my knowledge. But I would explain that when this document was first done, DNR required this document. So there was a learning process from the time that DNR activated until such time as it would come to a point to where the wells would need to be shocked. I talked with Lori on almost every occasion. I don't think we got to the point to where it said, I can't do this without seeing you first,
Okay.
which
thank
it
you.
may be. I understand that at the present time,
Thank
that
you.
is the learning process of I shouldn't be doing anything that Lori is not aware of or has already approved or disapproved. If she disapproves something, obviously I can't do that or
Okay,
shouldn't.
thank you. Okay, thank you. I ask that Exhibit A be admitted into evidence.
Mr. Blevins, do you have any objection to admitting Exhibit 8 onto the hearing record? And that is the 3 water facility operations agreement.
No objection.
Exhibit 8 is admitted onto the hearing record.
Okay. And so would you say that a request for payment from someone is a bill?
Pardon, what was your question?
Would you define a bill as a request for payment for
A
something?
bill. I don't send out bills.
I didn't ask if you send out bills. I just asked if a request for payment for services, would that be a bill?
Not in my process of asking for money.
So if somebody does work for you, fixes your car and gives you a request for payment, is that a bill?
That and for my car, I'm sure it probably would be.
Okay, so if you provide services for somebody and you ask for payment, would you call that a bill?
I already asked for payment a year in advance or a year behind,
Okay, thank you. You've answered the question.
a flat fee.
Thank you. So, who do customers call if you're not available, like in an emergency?
I've always been available. The only number that is provided out there per call is my number.
Okay, so if you're on vacation, who would they get in touch with?
Well, if I was on vacation or out of town, I would contact someone within my scope to go check that well, if I'm not there to do it myself.
Does DNR know who that person is?
I don't think so.
Okay.
But, well,
Thank you.
they may.
Have you filed that with DNR?
Filed it? No, not particularly filed that particular name with DNR, but I have provided to DNR the people that work on these wells, which is Rick Guile.
Okay, thank you.
Lori
Thank you.
Jean is another one.
So when you came up with how much you charge your customers for water, did you do some kind of calculation as to how much people would be charged? Like, is there-
Well, I suppose you could say that I calculated and come to a figure but the calculation was based on what the expenses are.
is there a formula that you used?
Oh, no, the plus and minus, times, divide. That's the only formula that I know of. And I've been a mortgage broker before, and I pretty well know how to put numbers together.
Is
I
there
know how to put expenses together also.
is there a formula or a plan that you could provide to the PSC to show us how you came up with those rates?
Well, I think I did that in that document that I provided, but what I provided was how much the electric was, how much the estimated maintenance and service per month would be, even provided what rent might be But I don't charge rent or pay rent because I own the building myself. So I didn't charge the water company or water people, in this case, with rent.
So it's just an
Just
estimate?
provided it.
Okay, so 5 years ago, when you were charging, you just came up with an estimate for the rate?
Pardon?
So you just came up with an estimate for what you might charge people for water?
I had to estimate that, sure.
Does everybody pay the same exact amount?
What?
Does everybody pay the same amount?
Yes, ma'am. It's all the same throughout the whole, spread it out over the different customers. All the same, which is the agreement to furnish water. And in that agreement, there are charges for also the residence itself, and also for, if you own a pool, there is a separate charge, which is in addition to the 55. That's $180 a month, or a year, or $15 a month, depending on how you actually want to pay it. And I think at one time I even offered discounts if they wanted to just pay it and not have to worry about it month to month. And
Okay. So in going back to what you said at the beginning of your testimony, you said some of the deeds that you have, or some of the ownership records that you have filed with the recorder's office and some you haven't?
that's correct.
Okay, so the ones that you have filed with the recorder's office, you pay property tax on?
Yes, ma'am.
Okay, so the ones that you have not filed, do you not pay property tax on those?
No, not personally, but taxes have been paid on it by a different process.
Okay,
Our
thank you.
county is
Thank
not
you.
up to date, if
Okay, thank
you
you.
really want to know the reason why.
Yeah, I think you answered my question. Thank you. So you talked about collecting back payment from people that owed you money that, that hadn't paid and they, owed you past due money. Does everybody pay the same amount?
For the back,
Yeah,
no, they do not. That's a particular situation.
so,
If you look at, if you're a, if you're a water person, I mean, you're using the water off a well, and you haven't paid that bill to anyone, me or anybody else, for a year or 2 years, and in some cases 5 years, then I give them an opportunity to make that payment. Obviously, it's kind of hard for people to pay cash all the time. But the responsibility of making that payment, I offered to them as a past due account set aside, so that they wouldn't be subject to any late fees because of the way that the agreement is written to furnish the water and the payment.
okay, so there's no there's no uniformity, excuse me, there's no uniformity between
For the past due
customers
account,
on,
no, just the ability of the individual without interest.
okay, and it's just based on whatever you decide, correct?
Not what I decided, it's what they were able to pay.
But it's based on what you and that person decide?
That's correct. It was,
Okay. All
I
right, thank
allowed
you.
them to do that.
Okay,
No
thank you.
other,
Thank you.
they didn't have any other choices because they couldn't do anything else.
Okay, thank you. Okay, In your data request responses, you said you had, getting your receipts was time-consuming and too hard to get together. Is that because your records are
And
too
what,
voluminous, or you have trouble getting your records together?
what was the question?
In your response to the staff's data requests.
Oh, data requests?
You
Yeah,
said
you
that-
were asking for information there. The way I read that was not available.
Why aren't they available?
Well, because of the situation in the beginning. 20 years ago, they didn't do things exactly the way they do today, especially contractors, surveyors. So in order to get that information and get it properly to you, I would have to go to the surveyor, research his records, or ask him to research his records and provide me with a legal description, for example, for a well. Or did they actually, when they put that easement in, did they write a description? If they didn't write one, which is sometimes the case, I would have had to ask them to write the description or write it myself, which I'm capable of doing that also.
Okay. What about your records? Were you able, you said it was hard for you to get your records together to answer some of these DRs because it took a lot of time?
Because the answers and the records have to come from other people, like surveyors or the owners or the attorneys that are maybe involved at that time.
Okay.
You're talking about ownership, right?
Well, I'm talking about your records in general,
What records in general then?
just your business records.
My business records, my accountable, the records that show where they make payment? Is that, I don't know what you're referring to there, I guess, specifically. I do know that it takes time for me to get through other people to get the proper records that you were asking for at that time.
Okay, I'll just withdraw that question. I don't have any other questions. Thank you.
Are there any commission questions? Commissioner Hahn?
Thank you. Thank you, Judge. Appreciate it. Thank you, Mr. Blevins. This is not a question, but I just want to let you know that I appreciate you being here and appreciate your testimony today. I know this is a time-intensive process, and I don't think it's unusual that people haven't heard of CCNs before. People in the regular world have usually never heard these terms.
No.
So, I just want to let you know that we appreciate your testimony and your travels to inform us of your side. Thank you.
Are there any other commission questions? I hear none. Mr. Blevins, I know you expressed yesterday that you have a doctor's appointment, and so we need to get you out of here fairly quickly. I'm going to ask you a few questions, not all the questions I had, but if you can keep the answers short, that would probably speed the process. So you had indicated you initially owned 20 wells, is that correct?
24 wells.
24 wells. And you owned those outright?
Some of them were outright. The other ones were either by contract and later fixed and disposed of. Not disposed of, but disposition, other disposition made of the well properly.
How many wells have you sold since you first had contact with DNR?
Well, I've had contact with DNR for a few years, but I would have to say maybe half. I don't know.
How many wells have you sold since you've had contact with the PSC?
PSC, I believe 8. 8 or 9, I think.
Okay. Now, Mr. Clover Sy said yesterday that he visited 16 wells with you. Was that the total at that time?
I don't know. I don't know when he visited the wells.
But you're now down to 8, correct?
I'm down to 8 wells, yes, sir.
And that would be 4 on the Charity system, 3 on the Misty Mountain system, and 1 on the Rolling Hill system. Is that correct?
3, you say 3 on Misty Mountain?
Yes, you said, or yesterday you said it was 5, but now 3 because you disposed of 2.
Yeah, that's correct, yes.
So I'm getting 4 plus 3 plus 1 equals 8.
That's correct. The 8 wells.
How many current connections are there on the Charity system?
On the Charity system, I'd have to look at my records, but I think it's 22.
There's 22 connections?
I think so.
How many households?
22.
Now, before you had expressed that the only one that you still felt would fall under DNR regulation would be the Rolling Hill system
That's correct.
with 19. Why would Charity, if it has 22 connections, not fall under their jurisdiction?
Well, the guideline is 15 connections or 25 users, individuals. So if you take, at that time, 4 wells, there's 4 wells. One of them is non-operational. That's the reason why you say 3 on Charity. There was 4 wells. The non-operational well is, I don't count
Okay.
at the present time.
How many connections are on the Misty Mountain system?
On the Misty Mountain would be 14, probably 14.
14 connections, and you indicated there were 19 on the Rolling Hills, correct?
19 on Rolling Hills. On Misty Mountain now, there's 14 without the connection to the Pulaski County, and Pulaski County is connected to 5.
Thank you. Now, you indicated you owned an antique store.
Yes.
Do you have any other businesses?
Not at the present time, other than I do construction. I have
Kind of construction?
backhoe. I construct sewer systems, water lines, backhoe. I've also do remodeling. I don't do that much anymore. I also operated salvage, tear down old houses or and reclaim lumber in old houses. I do that. They
Do you owe loans on any of the wells?
what?
Did you take out loans to buy any of the wells?
No, I did not.
Now, you indicated in your opening statement that the wells barely cover their costs, and you've reiterated that here today in your testimony. If that's the case, are you running these wells for profit?
No, sir. I'm not running these wells for profit in that respect. I run the wells for the investment. And if we go back to the reasons why I took these wells, the HOA would be paying for the about $3,000 per connection to become a part of that HOA.
So, and I'm sorry to interrupt you here. Like I said, I want to keep the answers short and get you out of here. So when you say that it's for the investment,
That's
what
correct.
you mean is instead of running them from profit, you're hoping that you will glean a profit at the end when you sell the wells.
Yes,
What you call it, you're calling it an equitable solution.
equitable solution to my investment. That's correct. On a monthly basis, I usually had to subsidize the expenses. Obviously, in my opinion, in my record keeping, I owe $40,000 for repairs and upkeep and et cetera, and plus the last recent upgrade on the Rolling Hills well, and I think there's a balance of about $14,000 there.
So 50,000, and I'm also testifying, or I did say that there's about $5,000 to $10,000 probably needs to be spent on bringing them up a little bit more.
But you currently own and operate these 8 wells, correct?
Yes, I do.
And from them, you distribute water to individuals, correct?
I distribute water, yes.
And you do that through a contractual agreement whereby they pay you for the water they receive, correct?
That's correct.
Plus expenses that you have in regard to, as you indicated, electricity to get water out of the ground requires quite a bit of electricity.
Yeah.
And you would agree that a well is a water source, correct?
Yes, it's a water source.
Now, the other day, both DNR witnesses, I believe, said at different times that in regard to the topo well, they had several times, I don't know whether there were suggestions or directives, but indicated to you what they felt needed to be done to bring those wells up to standard. And they indicated that there was a failure on your part to follow through and do that. Is there a reason, and you indicated today that you had an awareness of what needs to be done that seemed separate and apart from what DNR dictated. Was there a reason that you chose not to do the things that DNR had suggested or directed?
No, they suggested as maybe places to look and investigate about that. I didn't refuse to do what they wanted done. They, in my opinion, when they talked about digging up the pitless, I think they've mentioned that I refused to dig up the pitless. I never refused to do it. It was the time frame and the requirements of what they wanted. They didn't want me to dig up anything unless everybody was there. DNR, Lori, myself, and whatever. And we never could get that together for whatever reason. One of the reasons was that they asked me to dig it up and expose it during a time where the ground was frozen, it was cold, or muddy. On 2 occasions, I remember that very clearly, because I said, well, if I start digging up the front of that where the pitless is, then I'm going to damage it by doing that. I told them, I said, I prefer not to do it. And they said, well, their reply at that time, for that particular that I remember, they said, well, do you want us to hire somebody to do it? And I said, no, we don't need to do that. I've got my own backhoe. I've got 50 horse of backhoe here. So I can dig up anything I need to dig up. But later on, shortly after that even, I had Rick Guile, who is the well, not mine, but the fellow I go to help me determine what's going on with the well. Because he's more knowledgeable, and he fixes well. That's what he does. He's a pump service. To help me determine what the real problem was with this well, throwing out E. coli, and which is a very serious problem, and I recognize that, and I'm concerned about it, and still am. What else can we do to see what's going on? So we got his video cameras and all of his other type of equipment, and we inspected the pitless. There was nothing wrong with the pitless. I guess DNR felt that I was evading them or telling them a lie or in some way avoiding them. I was not avoiding them. I was trying to get to the bottom of what the real cause of that problem is on that well. There was nothing wrong with the pitless at that time. But we did discover that the line, the pipe that connects onto that pitless was busted below the pitless, but it had been repaired. It had been repaired, and I remember paying another pump service to repair that, but I did not tell them to repair it the way it was.
Okay.
That's another pump company that I will never do another business with at all.
Mr. Cloverside from DNR testified that he had talked to you and you indicated that you had, and he says that you indicated you had shocked the wells prior to realtors coming out to take samples and prior to DNR inspections. Did you tell him that?
No, sir. Prior to a DNR inspection was not a common practice for me to do. DNR was there for a different reason. We tried to, it was a common practice when a realtor wanted to take a sample, for example, for the lenders. That's the time that maybe a week before that, we would shock that well for them to ensure that there was nothing wrong basically coming from the well, because they usually wanted to take that sample from the house or in some cases from the well. Taking those samples is a delicate process, and we really don't want to have chlorine in it when they're taking a test and then they test and get chlorine. Bleach is chlorine also. Some people may not understand that bleach is actually less powerful than the chlorine tablets that they use in these wells. I don't let any of the well people toss chlorine down the wellhead, but they do. But they'll toss a whole handful just down there and then walk away. I don't like that, but it was a common practice and had been for 20 years. That was something, I guess, normal, and I just followed through with that normal. Since that time, the learning process, again, is another reason why I agree with DNR. They have more knowledge and more guidelines and rules to follow that make sense.
It was indicated that among the other things that need to happen at this point from DNR is that the topo well needs to be capped and that something needs to be done if you've taken a well, I believe, on the charity system that's not currently being used, that those wells need to be plugged or in some other way decommissioned, for lack of a better word. There have also been mentions here or there of other issues with wells. Given that you're down to the 8 wells right now, how long do you believe it would take you to bring those wells into DNR compliance?
It would, I would have to contact Rick Guile and get his schedule.
Okay, so the answer is you don't know, or do you have any idea of a time period whatsoever?
I think it would probably be within maybe a 90 to 120 days. Just knowing that people are busy at this time and the proper people to actually do that work.
And
I can't do it myself anymore.
Now, DNR also said that they're drafting a non-compliant well agreement, correct?
Yes, sir.
And that you've been given some time period to do some things within that time period. Do you believe you're going to get that done within that time period?
Oh, yeah, yes, sir. Some of it has already been done. And reports have been made back to the DNR through Lori Jean. However, I also understand that besides Lori, I need to reply to it also as the owner.
Those are all the questions I have. Does staff have any questions based upon bench questions?
I don't have any, no.
Any, well, you don't have redirect on this one, so.
No, I don't.
Mr. Blevins, is there anything else you wanted to tell the commission before I conclude this hearing?
At this point, I don't think so. I just asked for consideration, that's all.
Okay, I would like to echo what Commissioner Hahn said. I do appreciate your time today. I appreciate your explanation. I wish, in a lot of ways, that I was as articulate as you are. You're extraordinarily articulate when you were explaining this to me, so I appreciate that. Is there anything else that needs to be addressed at the commission at this time before I adjourn this hearing?
I don't think so. Will there be a briefing schedule or?
I hadn't anticipated ordering one. Did staff want to do a brief?
I'd prefer to do a brief just to put our argument together.
Okay. Mr. Blevins, do you understand what a brief is?
Well, I'm pretty well know basically what a brief would be, but yes, sir.
It's basically a short, it is, what staff will do is, it is not actual evidence, it is more along the lines of a closing argument. And it says, looking at the evidence from my perspective, here's why I think I should win. And that's essentially it. How long would staff need to do a brief in this case? I'm not going to do multiple rounds of briefing.
Oh, no. 20 days,
20 days?
15 days, something.
Now that presents a little concern to me because the thing is, staff had initially asked for expedited treatment of this as quickly as possible, and I set a
10
hearing
days.
date, and then staff requested to continue that hearing date.
10 days.
10 days? I'm not trying to shorten it too much.
That's fine. 10 days is plenty.
Let me, and I'm cognizant that staff is busy. I wasn't saying that to back you into a corner. Mr. Blevins, do you object to 20 days for staff to do a brief?
Yeah, I have no objection. I understand that time is value.
All right, well, today is the 26th.
I mean, you can make it less than that. 2 weeks is fine. We do.
How
would wait
about,
for a transcript?
I'm sorry?
Yes, we would need to
It'll
wait
take
for a
about 10
transcript.
days for the transcript.
Okay,
I'm
so-
not, I don't see any need to expedite this transcript. We're looking at about 10 days on the transcript. That's about where they've been hitting.
Okay, that's fine.
In that 10, I believe our contract says 10 days. Some days they've been, some instances have come in at longer than that. If the 17th of November is a Friday. I know that typically we don't try and order everything on Fridays, and I'm not saying that staff can't get it in before then, but if I set that 17th date of November, is that sufficient time for staff to do a brief?
Sure.
Okay, I will order briefs for the 17th of, I will set a brief deadline of the 17th of November for briefs from staff and Mr. Blevins. Mr. Blevins, I'm not going to force you to write a brief because I think that's unfair, but if you want to provide any sort of writing as to why you think this hearing should go your way, or if you want to provide argument to that, that same deadline will apply to you. You will, so you will also have till November 17th if you want to submit a brief as to why you think that you should prevail in this. Bear with me just a moment. And I will try and follow up by the end of the day on Friday with a written order explaining the briefing schedule.
Okay, thank you.
Is there anything else the commission needs to address before we adjourn this hearing?
I don't think so.
Mr. Blevins, you had no exhibits. Staff, I believe you only had 8 exhibits, and all of those has been admitted.
Correct, thank you.
I'd like to thank everyone for this time over this 1.5-day hearing. It went on longer than expected, and I think everybody conducted themselves very well. I appreciate that. And with that, I appreciate everybody's participation, and I will adjourn this hearing. We'll go off the record.